You're on mute, sir.
I will start again. Good morning, ladies and gentlemen. Welcome. Before I begin, can everyone hear and see me? If you could just give me a wave. Good. Communications coming through now. OK, well, it's 9:30 and time for me to start this examination hearing into the Castle Point Borough Council Community Infrastructure Levy charging schedule. For the record, my name is Mike Hayden. I am a planning inspector. I'm a chartered town planner and the examiner for this charging schedule. I've been appointed by Castle Point Borough Council to examine its draft community infrastructure levy charging schedule and to prepare a report to the council on the legal compliance and viability of the charging schedule, and if necessary, any changes or further work to be undertaken before it is adopted. Sorry, just turning my sound up a little. I have a few opening announcements and comments, which should take me around 15 minutes. I'll then invite the council to make their opening statement, and following that, we'll proceed with discussion of the first main issue, which will be on infrastructure planning, and I'll ask other participants to introduce themselves at that point. So just as a reminder, this hearing is being live streamed and it's being recorded by the council. The recording will be made available for everyone to view on the examination website after the hearing is finished. Again, just as a reminder to everyone, although I'm sure you're familiar with these proceedings, if you could just make sure that any mobile phones or devices other than the one you're using to participate in this session are switched off or are at least on silent while the hearing is in session. Thank you. And please would you also ensure, as you have done, thank you, that the microphone on the device you're using is muted until you're invited to speak. Really that's just so we can avoid any disturbance from background noise or feedback from microphones on other devices. Thank you. As participants, you'll have already met Andrea Copsey, who's the programme officer for the examination, but just for the purpose of the recording, Andrea, if you could just introduce yourself.
Yeah, sorry, good morning, sir. Good morning, everybody. I'm Andrea Copsey, programme officer for the CIL.
Thank you. Thanks, Andrea. And just to confirm that Andrea is independent of the council and has been working on my behalf to manage all of the administrative arrangements for the examination and for this hearing. So just for the record, Andrea, thank you very much for your work so far, for the smooth running of everything that's taken place so far. Again, if you need to contact me, as you have been doing outside of the hearing, you should do that through Andrea, please. Thank you. OK, so my role as the examiner is to establish, firstly, whether the council has complied with the legal requirements in preparing and consulting on the draft charging schedule. Secondly, it is to establish whether the schedule is supported by appropriate available evidence on infrastructure and viability. Also to establish whether the levy rates proposed are informed by and consistent with the viability evidence. And then lastly, that the evidence shows that the proposed rates would not undermine the deliverability of the local plan or put at risk the overall development of the area. So in terms of the possible outcomes for this examination, just to be clear, there are three possible outcomes. Firstly, approval of the charging schedule. That is, if the legal requirements have been met and no changes are necessary. Secondly, approval of the charging schedule subject to modifications. So if the schedule can be modified so as to comply with the drafting requirements. Or thirdly, rejection of the charging schedule where the council has not complied with the drafting requirements, and this cannot be remedied by modifying the draft charging schedule. So I will be preparing a report on my findings after the hearing, but obviously the hearing today is important for me to clarify a number of matters. So just in terms of these hearing sessions, the sessions this morning, this afternoon, so my briefing note, which for the record is on the website, is EX07. That outlines the procedures to be followed at this hearing, the way in which written representations will be dealt with, and the availability of information. The way I expect participants to conduct themselves and participate in the hearing is also set out for ease of reference in my virtual hearing etiquette guidance note. That's EX10 on the website, and I know that's been sent to all participants with your invitations, so you'll familiarise yourselves with that. In terms of the hearing programme, the final hearing programme, which is EX09 on the website, that was published last week, and that's the programme that I'll be following today. So just in brief, this morning the hearing will run until 1 o'clock. We will take a half-hour break around 11 o'clock, again just to avoid getting tired with the use of screens. So we'll take a half-hour break at 11 o'clock. This afternoon we'll resume then at 2 p.m. and we'll have a break at around 3:30 p.m. I'll aim to close by 5 to 5:30. If it takes us that long, it may take longer. Depends on how the discussion goes, but that's the plan for today, and I'm hopeful we'll conclude proceedings today. So just to be clear, during the breaks at mid-morning, lunchtime and mid-afternoon, if participants would please remain in the hearing session on this Teams platform, but if you just turn your cameras off and mute your microphones, I think a screensaver should come across just to indicate that we're on a break. Thank you. And just to say, if you do have any connectivity issues whilst you're in session, please follow the suggested steps in paragraphs 11 and 12 of the virtual hearing etiquette guidance. Again, you'll be familiar with those. So the hearing will be in the form of a structured discussion. I will lead that discussion following the programme, and it's based on the main issues and questions which have been circulated, and I have a number of supplementary questions to follow up on those. What I will do is invite people to speak at particular times, but if you have something to contribute at the appropriate part of the discussion, if you could please indicate your wish to speak by using the raise hand function on Teams. And again, I just ask that you keep your cameras switched on for the entire session, if at all possible, just so I'm looking at your faces rather than some icons on the screen, but also with your microphones muted until you're invited to speak. So there may be some issues or questions on which I have enough information to reach conclusion, and I'll indicate that as we go along. So there may be little or no discussion on those. After the hearing sessions today, the examination will remain open, and that will remain open until my report is submitted. However, after the hearing, to be clear, I won't accept any further representations or evidence, that is, unless I've specifically requested it. So does anyone have any questions at this stage on the procedures or programme? No? Okay, thank you. At this point, I'm going to ask the council to make a short opening statement. And as part of this, I've asked the council to confirm or to include the following information: whether the schedule has been prepared in accordance with the statutory procedures, in accordance with the council's adopted local plan and infrastructure delivery plan, and also in accordance with the consultation requirements set out in the CIL regulations, but also to confirm that it's supported by a viability study and that there are no fundamental procedural shortcomings. So if I could ask the council, please, to just make its opening statement, and perhaps whoever's speaking first, you could just introduce your team before you do that. Thank you.
Good morning, sir. I'm Amanda Parrott. I'm the Planning Policy Manager at Castle Point Borough Council. I'm joined today by my colleagues Tim Parton from DAC Planning, who has worked with us on our infrastructure delivery plan, and Russell Porter, who is our viability consultant from Porter Planning and Economics, and his colleague Tom Marshall, who's also worked on our viability study. Thank you for the opportunity to make this statement.
Ms. Parrott, I'm just, your microphone is not working. Ms. Parrott, so, yeah. Ms. Parrott, can I just say your sound isn't coming across. I know I've asked. Yeah, I'm not hearing anything, Ms. Parrott.
Not working.
Ms. Parrott, can you hear me?
Not working.
Is it worth just turn your camera off and see if we can? If you just turn your camera off and we'll see if we can hear you. I'm not getting anything through at the moment.
Amanda's just seeing if she can get a computer up and running. Apologies.
Okay. Okay.
She can just read it.
Ms. Parrott's just going to rejoin the meeting. Hopefully that'll improve her connection.
Thank you. We'll just wait.
Could Amanda read it from Russ or Tim's screen? I mean, if you're in the same room, and it doesn't seem that you've got the connectivity problem, Tim and Russ.
I think at the moment it's probably easier. Amanda's just almost rejoining again rather than time she moves over to here.
Okay, sure.
Thank you.
I might have to move. Yeah.
How are we doing?
Andrea, would you be able to send the invitation to the meeting to Maria Hennessy?
Yeah.
And then Amanda is going to join on that computer.
Okay, no worries.
Mr. Parton, if you're both in the same room, is it possible for you to screen share, so to have both of you on the same?
Yes, it could well be.
On the same Teams.
Yeah, let's see if we can work that out. I'll just be 1 second.
Okay.
Just sent the email to Maria.
Okay, can you hear us okay now?
Not that well.
Yeah, until we've got the other computer up and running, we might just have to speak quite loudly into this microphone, if that's okay.
Just if you can just move forward a little, come forward a little to the microphone. Thank you. So Ms. Parrott, you still have your image on the screen separately. What's happening there?
It's frozen and stuck. So I suppose if we want to get on, I'll get on this, and Maria will work on making my computer go away at some point.
Okay, so someone's working on that. All right.
Yeah.
Well, look, I can hear you. Can everybody else hear Ms. Parrott speak? Yeah. Okay. Please carry on.
Sorry about that, sir. Yeah, so infrastructure capacity and the ability to access community facilities and services is a critical issue for the residents in Castle Point. Therefore, putting mechanisms in place to ensure that there is the right levels and types of infrastructure in the borough to meet the local needs is an important component of building the case for future growth and development in the borough. Castle Point is a small area, tightly constrained by the green belt. Development and growth therefore occurs on smaller sites through redevelopment and densification. Typically, these small sites are ineligible for making Section 106 contributions, or else the contributions that could otherwise be secured are not sufficiently meaningful to deliver an infrastructure project. However, the combined impact of these developments on smaller sites has been increased pressure on our roads, on our healthcare facilities, our education and childcare facilities, our open spaces and sports provision, and also on our flood prevention and drainage infrastructure. The introduction of a community infrastructure levy at this time enables the council to ensure that all developments, including those occurring on smaller sites, contribute towards the infrastructure needed to support a growing population and increase pressure on services. Whilst the new local plan was found sound, the council took the decision to withdraw it in June 2022. However, the 1998 adopted local plan still has effect and it is still possible due to the land use policy set out in that plan to deliver around 1,474 homes sites within the urban area which do not currently benefit from planning consent. This housing figure is based on the urban land supply arising from the Strategic Housing Land Availability Assessment and windfall assessment undertaken by the council and found to be sound as part of the local plan examination. These urban sites have a combined infrastructure requirement of the order of £20 million. It is anticipated that due to the site mix, only around £2.2 million of this can be secured through Section 106 agreements, and therefore CIL will have an important role to play in addressing the infrastructure funding gap. CIL is expected to raise of the order of an additional £7.8 million for infrastructure from the urban sites identified. In the absence of CIL, the council would expect the infrastructure funding gap to worsen significantly. We cannot therefore wait to get CIL in place alongside a new local plan, as the worsening infrastructure situation will frustrate residents and stifle their buy-in to development proposals. It is therefore critical that we get a CIL in place as soon as possible, and we welcome the examination of the draft charging schedule at this time. We will of course keep CIL requirements under review alongside the preparation of the new plan that we intend to start work on in the new year. And we will of course propose revised rates if necessary to align with that plan as permitted by the regulations. Within your guidance note for this hearing session, you ask the council to confirm certain points in relation to the procedure applied in the preparation of the draft charging schedule. In terms of the draft charging schedule submitted to you for examination, I can confirm that it's been prepared in accordance with the Planning Act 2008 and the associated CIL Regulations 2010 as amended. Consultation has been undertaken in accordance with the CIL Regulations as amended. The requirements of the regulations were complied with both during the original consultation in the period from November to December 2021 and also during the additional consultation that was undertaken in the period from July to September 2022. The relevant local plan for the purposes of the draft charging schedule is the 1998 adopted local plan. It sets out land use policies which have enabled the supply of the development sites and the potential infrastructure impact to be determined. It is therefore possible to provide an estimate of the total cost of infrastructure required to support the expected development in the area, taking into account other expected sources of funding as required by Regulation 14(1)(a) of the regulations. The relevant infrastructure delivery plan is the Infrastructure Delivery Plan 2020, as updated by the Infrastructure Delivery Plan Addendum A 2022, An infrastructure schedule has been provided to the examiner, meeting the requirements of Regulations 14.1a and Regulations 14.5. The CIL viability study, dated August 2021, supports the draft charging schedule submitted. This aligns with the requirement of Regulation 14.1b, and an additional piece of work was provided to you specifically in relation to Canvey sites, which underpins that further. The Council is therefore satisfied that it's complied with all the relevant procedural requirements. Thank you, sir.
Thank you. I don't know whether you before we start to discuss the first main issue, whether it might be an opportunity for you just to see if you can get back onto your own laptop.
I'll give it a go.
Just before you do that, I'm just going to ask the other parties around the table, as it were, just to introduce themselves. So, Mr. Ryder, Mr. Tatton, please.
Good morning, sir. My name is Liam Ryder. I'm an Associate Director at Code Development Planners, and I'm instructed as a planning consultant on behalf of This Land, who were promoters of previous local plan site HO13.
Morning, Mr. Ryder.
Morning, sir. It's Neil Tatton from Resolve 106, Affordable Housing Consultancy. We're working in conjunction with Code Development Planners on behalf of This Land in relation to the subject site referred to.
Morning, Mr. Tatton. And Andrea, we were due to have Mr. Wiltshire from Persimmon. Is Mr. Wiltshire not attending?
I've not received any email from him to say otherwise.
Okay. Okay, thank you. How are we doing? How's Miss Parrott doing with reconnecting?
I think it's working.
Excellent.
Mr. Parton's just got to put his headset back in, otherwise we'll get an echo.
Okay. Wait for Mr. Parton. Okay, good. So we'll move on to discuss the first issue on the programme, which is infrastructure planning. It's questions 1 and 2 in the main issues and questions. Just before we do that, again, if I just remind people that you should have already provided your evidence in your original representation in your hearing position statement. So just to be clear, the hearing sessions are not an opportunity to submit anything further. So any comments you make during the hearing session should therefore relate to the points made in your original representations. I'm sure that will be the case, but just as a reminder, and again to say, I've read your representations and your hearing statements, so there's no need to repeat what you've said. The purpose of the session is for me to seek some clarification on further information on any outstanding issues. But if you are referring to your any of your evidence, if you just give me a page or a paragraph number in the relevant document, just so that I can note that down and review it later. Okay, if I could just say by way of a sort of preamble, so in the MIQs, in the main issues and questions, I set out 4 main issues for the examination. Those are: has the charging authority, has the council complied with the procedural requirements and the CIL regulations? Is the CIL charging schedule supported by appropriate available evidence on infrastructure planning and economic viability? Are the proposed CIL charging rates informed by and consistent with the evidence? And does the evidence show that the proposed charging rates would not put at risk the delivery of the relevant development plan as a whole? Does the evidence show that an appropriate balance has been struck between helping to fund the new infrastructure required and the potential effects of the levy on economic viability of development across the district. So those are the four main issues. On the main issue A, the council has confirmed its position on the legal and procedural requirements. What I'm going to do is just ask the council if you can supply a copy of your opening statement so we can put that into the examination library, please. If we can just give that a reference number as well. So council has confirmed its position, and I'm generally satisfied that I have enough evidence on most of the issues under main issue A in terms of legal compliance and procedural requirements. That is with the exception of the question as to what is the relevant plan. That's the first thing I want to come on to. So as we go through the discussion today, just keep in our minds there are really three main issues that I want to explore further. First is whether the DCS is supported by appropriate available evidence on infrastructure planning and economic viability, both for residential development and subsequently for retail development proposals, and that will include whether the evidence shows that CIL is necessary to support development in this borough. Secondly, are the rates for residential and retail development informed by and consistent with the evidence? And thirdly, whether the proposed rates would put at risk the overall development of the borough. So I mean, just keep in mind those are the three things that I'm looking to explore further today, but we'll move on then first to deal with infrastructure planning. So the first question I've asked is on the relevant plan, and I do want to ask some supplementaries on that. So the question was, is the 1998 local plan capable of constituting the relevant plan, which is the term in the PPG, for the purpose of setting CIL charges, given that its housing and economic strategies are no longer relevant and the development identified in it has already been delivered? And if it is capable of being the relevant plan, how would the proposed CIL help to support the implementation of the 1998 local plan? So I'm very grateful for your responses on that. And I've read those, and I think I just wanted to summarise my understanding of what's been said and what I'm clear on, but you can correct me if you think I'm wrong. So there's three points just to make. Firstly, I'm clear that in terms of the legal requirements, the appropriate balance in Regulation 14 of the CIL regs, which of course lies at the heart of the setting CIL rates. So that appropriate balance requires the charging authority to calculate the cost of infrastructure required to support the development of the area. So in the legislation, a plan is not mentioned. Okay, so that's the first point, is my understanding of what you said and my own knowledge of the procedures. Secondly, the term relevant plan arises in the planning practice guidance, not in the law, but it is clear from the PPG that the evidence on the cost of infrastructure needed to strike the balance should be informed by the relevant plan. So that's my understanding of what the procedures and the law say. So the role of the relevant plan is important in the CIL setting process, and we can't simply set that aside. I don't want to spend a lot of time on this question because you've given me fairly full responses on this, and we will deal with the detail of the infrastructure costs and how those have been calculated under question 2. What I want to do is just to ask the council to clarify something about the relevant plan. So I'm going to just address this to the council first. I'm happy for others to come back in afterwards. So, council, you've explained why you regard the saved policies of the 1998 local plan as the relevant plan, and that it now provides the framework for determining planning applications for development, and therefore the basis for understanding the cost of infrastructure required to support that development. What I would say, though, is that the PPG defines the relevant plan as any strategic policy. You said in your evidence that the housing and economic strategies of the 1998 local plan only extended to 2001, so are no longer relevant strategies. So my question really is on that issue of strategic policies. Be grateful if the council could clarify what are the strategic policies in the 1998 local plan which provide the basis for constituting the relevant plan for the purposes of CIL setting. So what are the strategic policies?
Sorry, I was just finding the correct pages. So policy H2 of the existing local plan is still extant, and that identifies that land allocated for residential purposes within the local plan will be retained for such purposes, and development is permitted in those areas for residential purposes. We then have policy.
But you say that's a strategic policy?
Yes.
Okay.
It sits under the housing strategy element of that plan. Land allocations policy H3 is still extant and still has sites within it that are to be delivered. And then in terms of economic development, policy ED1 is still extant, as is policy ED2. And then you move into DM policies, which still extant, which protect the existing employment areas as well. So policy ED3. And the retail strategy policies, policy S1 and S2 are still extant.
Can you just tell me what those do?
The S1 is the location of retail development, and S2 deals with shopping facilities at the Rayleigh Weir, which is a particular out of centre retail site within the borough. And then we have policy CF1, which I just need to quickly skip to give you the right title, which deals with social and physical infrastructure and new developments. So that sets out the council's approach to infrastructure, seeking infrastructure where required alongside developments. And then there's specific policies within that chapter that then go on to deal with the different types of community facility, although it's more aimed at that form of development rather than development related development needs. So
yeah. So if I just look firstly at that policy H2, so land allocated for residential purposes within the local plan shall be retained primarily for that purpose. Yep. Development would result in the loss of large sites allocated for residential purposes would be refused. It reads as a development management policy, if you don't mind me saying, not wishing to split hairs, but it doesn't read to me as a strategic policy. Strategic policies normally set the strategy for an area. And so how do you respond to that?
So within Castle Point, or on the proposals map that goes with this, those areas are washed in a salmon colour, and that enables residential development to occur within those areas across the borough, and has been able to do so since 2001, when policy H1 expired. And since that time, we have seen that's acted as our strategy, and we have seen the increased intensification and densification of those areas, and we expect to see that going forward as well. So our strategic housing land availability assessment has been able to assess the capacity of that area going forward. So it is providing a strategic approach to the council in terms of intensification, densification, particularly if it's where it's read alongside policy H14, which allows for residential development over shops. So in particular in town centres, is helping to set that strategy in terms of the way that development is coming forward.
Yeah.
It hasn't frustrated development in those areas.
Okay. So just so I can be clear on what you're saying, so H2 talks about land allocated for residential purposes. So I'm assuming that's sites that are allocated rather than the general residential areas. I think you said that the residential areas were washed over, and that this policy provides some guidance. Policy H2 provides guidance on development within those areas, but I think as I read it, it is talking about land allocated for residential purposes will be retained for that, and development which would result in the loss of those sites would be refused.
That applies to the areas washed in salmon as well.
Okay, does it? Okay, is that clear from the policies map?
Yes, you can see the salmon, and it's got an annotation associated with it.
Okay, okay, okay. Well, I'll have a look at that. Okay, and just let me go to policies ED 1 to 3. So ED1 allocates a site north of Northwick Road. ED2, sorry.
Yeah, and both of those sites are still, well, one of them's in the process of coming forward, and the other one's still to come forward. We're working with, it's the same site promoter, so we're working with them on that.
Okay. Policy ED2 establishes long-term employment needs.
Yeah, that's the site that's actually coming forward. It's ED1 that's still to come forward. So
okay. So again, that's the site allocation policy, and ED3 seeks to protect existing employment areas. Okay.
Yeah.
Okay. Okay, thank you. I'm happy to hear from either Mr. Ryder or Mr. Tatton on this as well. I don't know, Mr. Ryder, you want to make a response to that? And clearly your view is that the 1998 plan is no longer the relevant plan. What do you say in response to what the council have just said?
Thank you, sir. In terms of the strategic policies that Ms. Parrott has just mentioned, I think guided by the definition of strategic policies in the MPPF, which is that they address strategic priorities in line with the requirements of Section 19 of the Planning Compulsory Purchase Act 2004. I have no real issue with the sort of statements that have just been made to you in relation to those policies. They clearly do still retain a function in helping the council determine where new development is acceptable in the borough, and that includes the residential areas as indicated on the policies map. You have the benefit of our detailed representations and also our statement of common ground prepared with other participants in previous representations, so I don't wish to go over that in too much detail because I'm conscious of using examination time effectively. But I think we do have concerns about the 1998 local plan as a relevant plan. As you've noted, that plan is time expired. I think is accepted in statements that have been made by the council and other participants in previous representations and the hearing itself, that the housing requirement itself has been delivered in full at this stage. And so you could argue that its strategic purpose has been fulfilled at this stage. With regard to the sites that the council say could come forward under Schedule 1 of the draft CIL topic paper, we do have some concerns over the deliverability of those sites, as you'll have noted from our representations, sir, and appreciate that a CIL examination isn't necessarily the most appropriate format to go through the deliverability of those sites. But taking the strategic sites, as the council labels them, out of the withdrawn local plan, so if we leave those to one side for the moment, the sites identified through the strategic housing land availability assessment and windfall sites, the council's justification for those is a reliance upon the inspector's conclusions with regard to the windfall allowance in the local plan examination and his inspector's report that accompanied the withdrawn local plan. Our concern in relation to those is that there's no up-to-date evidence seemingly before us as part of this examination, as updated from 2018, as to whether those promoters and landowners are still intending to bring those sites forward. I'm happy to be corrected if I'm wrong on that, but I don't think I've seen anything as part of the examination to date on that particular point. And also just whether the council has undertaken any consultation with those previous site promoters and landowners to understand whether the imposition of a CIL levy in the borough would potentially deter them from bringing those sites forward. Now, I'm conscious of the viability evidence that's been prepared in support of the charging schedule, and I know that we'll come on to that in some more detail shortly. But I just thought it's important just to raise that particular question, because clearly viability evidence may say one thing, but those site promoters might think differently in terms of their experience on the ground. And also the point that's been made in the council's hearing statement that planning obligations will not come forward from sites under 10 dwellings. Now, I think the PPG is quite clear that that's specifically in relation to affordable housing. I've got no reason to debate that. And I think the wording is that CIL may be the most appropriate form of gathering contributions from sites of less than 10, but it doesn't rule out planning obligations. And I think having looked at Essex County Council's guidance on developer obligations, I note that for highways, it doesn't rule out seeking contributions from sites of less than 10 dwellings, and we're also conscious of our own experience for sites of less than 10 in the borough, and recent committee reports where, for example, planning obligations have been sought for Essex RAMS payments, for example. Now, I appreciate that those are small contributions compared to perhaps more significant infrastructure contributions, but it's just the principle of whether or not obligations can be sought from sites of that size. So I think that brings us round to our overall point, as you will have seen from our representations, sir, that we feel that it's more appropriate at this stage for the CIL charging schedule to be withdrawn and to be brought forward alongside a new local plan where that evidence base is up to date. The council can be satisfied of the specific infrastructure requirements arising from the sites to be allocated through that plan, and where there's more certainty on the deliverability of those sites. And then you, sir, could then be more informed on the aggregate funding gap and whether that is an appropriate figure which justifies the imposition of CIL. So I think that's the main point that I'd like to make this morning, on top of what we've already submitted to you in writing.
Okay.
Thank you, sir.
Thanks, Mr. Ryder. Okay. We will come on to talk about the list of sites in due course. So I don't really want to get into a sort of detailed discussion of those at this stage. But I'm just interested in hearing as a generality from the council about its reliance on those sites to deliver housing and the extent to which discussions have been held with site promoters recently to establish whether those sites are likely to be deliverable or not. In general terms, if you could just deal with that point.
So the list of sites that's been provided as Appendix 1 to the topic paper has been kept under review throughout the period since 2018. So if sites have gained permission, for example, if we know that they've fallen away because they've been developed for some other purpose, and so forth. And indeed, the figures for some sites have been updated where they've come forward for pre-apps as well. So we have been keeping the list up to date. In terms of the consultation for the CIL, we contacted all of the small, medium, all of the agents and builders that were on our database for planning applications and for building control, so they have been engaged on the rates that have been proposed. I believe that one agent has come back in respect of that. I think it was Contour Designs as part of the November consultation, and again as part of the consultation this summer. They represent quite a number of the small developers within the borough, so that possibly give that their representations will give you a view on the issues as they see them.
So yeah, in terms of the consultation that you've had then on CIL, are you saying you've purposely consulted on each of those in respect of the or with the owners or the agents for each of those sites, or are you saying you've consulted with agents for small developers?
More generally within the borough? Yeah.
Okay. Okay, thank you. Well, I've got nothing further to discuss on that. So, as I say, you both given me fairly full responses on that, and I have something from Simon as well as the statement of common ground between a number of developers. So I don't propose to discuss anything further on question 1. So unless there's anything anyone wants to raise, I'll move on to question 2 in the MIQs, which is infrastructure planning evidence. So again, I'll just read out the question for the help of the live stream record, just to remind us what this is about. So, is the infrastructure planning evidence set out in the infrastructure delivery plan, the IDP, and that's document sub 02 on the examination website? So, is the evidence set out in the IDP as updated by the addendum to the IDP? So it's a bit of a paper chase in respect of these documents. The addendum to the IDP, which is CPB C1N, again on the examination website, and also the topic paper submitted by the council, CPB C02. And both of those, the addendum and the topic paper, were the subject of the additional consultation in the summer. So is the infrastructure planning evidence in those 3 documents, is it appropriate, and is it sufficient to confirm an aggregate funding gap that demonstrates the need for a CIL charge in Castle Point? And if not, why not? So I have some supplementaries on this, both for the council and also for code. If I can again just sort of summarise what I've read. So I acknowledge that there is an in principle disagreement between the council and interested parties about whether any of the development which could be granted consent under the 1998 local plan provides appropriate evidence of an infrastructure need. So I understand there's an in principle disagreement. Don't need to discuss that further. As a scenario, though, if I were to conclude for example, that the 1998 local plan is a relevant plan and an appropriate basis to inform infrastructure requirements. What I want to get to the bottom of in this discussion is the true extent of that infrastructure funding gap. So I've got some further questions on that. I think the starting point for that is just to understand the amount of housing development for which infrastructure may be required. And there's clearly a difference between the parties on how much development could potentially be granted consent under the policies of the 1998 local plan, which may therefore be CIL liable. And I just need to understand the difference between those two figures. So I'm going to go back to Appendix 1 to the topic paper, and we can just pick that up. So that's the topic paper is CPBC 02 in the examination library, July 2022, and Appendix 1 to that. Now that lists sites totaling 1,474 units. So council referred to that in opening, and you say that those are all sites that can come forward, that don't have planning permission, they can come forward under the 1998 local plan. Just from the information that I've had from code, but also other information that's been submitted, a number of those sites do now have planning permission. Indeed, one or two had planning permission a while ago. And that's based on both, as I say, both codes evidence in Appendix 1 of their representation on the additional consultation. It might be useful just to open that as well. So if you could just refer to codes representation on the additional consultation, and go to the schedule at the back of that. I think it's Appendix 1. Yeah, it might be useful just to have that open as well. So we've got those two appendices open. I just wanted to clarify the position that you agree that the infrastructure costs for sites that have already got planning permission can't be included, clearly, because they've already been granted consent. There's already an assumption that if there are any infrastructure costs associated with those, that have been negotiated through Section 106. So just questions to the council. I presume you agree that the infrastructure costs for those sites can't be included.
Yes, I'll respond. Yes, we agree to that. Yes.
Okay. Sorry, just let me catch up on my notes so I know where I'm headed. Okay. Okay, so just picking up on that point, so there are a number of sites in that list which do have planning permission, and should therefore be subtracted from the total of 1,474. So I believe I'm right in saying, based on codes evidence, certainly, that strategic site, as it's called, HO21, land fronting Rayleigh Road, Thundersley, that has full planning permissions granted in August of this year. Yeah.
So part of that site does, but there's actually a significant proportion of that site that doesn't. So that's incorrect.
Okay. Okay. When we get to the end, I'm going to ask the council just to update this list, and perhaps to work with code in agreeing what can be counted and what can't. So just going down the list then, the land south of Heron Close, so this is strategic site HO29, South Heron Close at Canby Island, 24 capacity of 24 units. Again, that has a full planning permission, as I understand, from February 2021.
Yes, that does.
Yeah. So just wonder why you've included it in the list.
I don't know.
Okay, and the same applies to HO30, Haystack Car Park, Canby Islands, 14 dwellings, has a full planning permission from July 2019.
That hadn't commenced at the point, and it looks like it was likely to go out of time. I need to check the building control records on that one.
Okay. I'm not asking questions about deliverability here. I'm just asking simple questions about whether it's got planning permission and whether it can be counted as part of the total number of dwellings which could be delivered through the policies of the 1998 local plan, and therefore the number of dwellings that you can use to calculate infrastructure requirements and infrastructure costs. So just going down the list further, so the brownfield land register site CP 0038, High Road, Tarputs Town Centre, 40, and Benfleet, 40 dwellings. It is planning permission subject to a section 106, but so there's a resolution to grant planning permission subject to section 106. Is that still the case? Is that still pending?
That is still pending, yes.
Okay. Okay. I'm not going to go through all of them, but there are a number of other sites which, smaller sites now, SLAR sites, which have been granted planning permission according to the list there. And so what I would be grateful if the council would do and submit this to me after the hearing is just to work with code on this, so that there's an agreed position on which sites now have planning permission and no longer count as sites that could be granted consent in future under the plan, and then just to recalculate that that figure of 1,474. From the information I've been given, I calculated there were something like 200 sites with planning permission accounted for about 205 units. So it would bring the figure down to about 1,270. But I accept that figure may be wrong if you've got more up-to-date evidence on different sites. But yeah, I would appreciate that list could be updated. I've noticed that you had taken out a number of the strategic sites that had been granted planning permission, but that clearly didn't apply to all of them. And there are a number of the SLAR sites which appear to have planning permission already. Is that okay? Yeah.
That's fine. We can work through that.
Work on that. Okay, thank you. And if I can just come to code, yeah, Mr. Ryder, and you can say what you want to say as well. If you could just deal with this question. So you say that the dwelling figure should exclude all of the strategic sites allocated in the withdrawn Newcastle Point local plan. But some of those were also allocated in the 1998 local plan. And I guess what the council is saying is others are within the settlement boundaries, so that they're termed urban sites, and could come forward without further allocation. So would you agree with that? Is it still your position that none of those sites can really be considered sites that could be delivered under the 1998 local plan?
Thank you, sir. Just to try and take those in chronological order. First of all, more than happy to work with Castle Point Borough Council just to refine the list, and apologies if it's not quite up to date. We could only take it to a certain point, and clearly there was more information the council had the benefit of in terms of cut-off dates for implementation periods and that type of thing. So we're happy to work with Amanda further to this to make sure that you've got the benefit of correct information. I think in terms of the strategic sites, the point I think that we made in our written representations was in relation to the Greenbelt sites that formed the withdrawn local plan. Clearly, they no longer have a policy basis, and I think, in fairness to the council, the chronology, as you say, sir, in terms of trawling through the paper evidence base for this, the original IDP and the IDP addendum included those sites. The May 22 infrastructure schedule and the schedule appendix 2 of the council's hearing the draft CIL topic paper excludes them. So I'm happy to confirm that that's correct. In relation to the allocations that were within the urban area and so could come forward under the 1998 local plan, we are content that those sites can still come forward. But I think what I would highlight is a concern over the scale of the infrastructure funding gap in relation to those sites. And it's a bit of a comparison between both Section 106 obligations and anticipated CIL receipts here. So I do apologise for any confusion and happy to clarify where necessary. The original infrastructure delivery plan and the IDP addendum included information about taking education as an example, included requirements for education infrastructure on the basis not only of sites on their own, but cumulatively with other sites in the borough. And that related to sites, for example, on the mainland within Benfleet, Hadley and Thundersley. And clearly within each of those areas, there are primary schools which may require expansion. There may have also been requirements for a new primary school to be located on one of the Greenbelt allocations that have now been withdrawn. So happy to confirm that that's the case. But what we've noticed from looking through the various iterations of the infrastructure schedule, the contributions for those sites appear to remain the same, and it doesn't appear that there has been any reflection on where contributions or new infrastructure might be required as a in relation to that cumulative development no longer coming forward. And so I think for HO15, which is Scrub Lane in Hadley, for example, I had a quick review through the evidence base, and there's a number of sites attached to or added in addition to that site which could contribute towards an expansion of an existing school in that area. I think a 1.5 form expansion. Now, a number of those sites, including Land East of Rayleigh Road, will no longer be coming forward because they were in the Greenbelt. But the total infrastructure cost for HO15 is still the same. But I'm not sure that there's been any consultation with the education provider, so Essex County Council, to confirm whether those contributions should be revised. So I think there's a danger that the aggregate funding gap has been inflated, and I'm happy to be corrected if I'm wrong. But it doesn't appear on first look there's been updates in relation to the capacity of various types of infrastructure, including education, healthcare and highways, for example. And whether that's been translated into the updated schedules of infrastructure contained in the May 22 version and then subsequently the version attached to the July topic paper. And quite clearly, if there hasn't been that type of work undertaken, there's a risk here that the aggregate funding gap may have been inflated above where it should stand. And that's in addition to our point earlier, sir, about sites that may already have planning permission. So I think it would just be helpful to understand the council's position on that from our perspective.
Yeah. So just taking education as an example or as a starting point. So if I turn to just so I can understand the paper trail about it, if I turn to the IDP addendum, yeah, and I turn to the education infrastructure contributions required to support growth in the borough. So I turn to table 3. Yeah.
That's correct. It is table 3. Yeah.
Yeah.
So sorry.
Just on. So if I take site HO15, Mr. Ryder, just explain to me, to help me understand, make sure I've gathered exactly what you say. Just explain to me what your point is in relation to the education contribution that's been calculated as being required for that site.
Yes, sir. Apologies. It may also be helpful to refer to the original IDP here as well, which I do have the reference for that somewhere. Apologies.
It's okay. Yeah, it's sub 02.
Yes. So table 6 of that document, which is page 21.
Okay, yeah.
So you'll see for Hadley there are 7 sites that were expected to contribute towards a 40 place per year primary school expansion.
Mm-hmm.
And so the table at the end of that same document for HO15, so apologies sir, it's a bit of a jump, but page 149,
okay,
which summarizes all the infrastructure requirements expected of HO15 for
okay, yeah.
There, under reference 31 on that page, there is the 1.5 form-entry primary school expansion for Hadley, and you have the total cost associated with that at 272,756. And so if we then move to the IDP addendum, as you say, sir, table 3 confirms that that figure remains the same.
Yeah.
And then if we then move to the May 22 infrastructure schedule,
yeah,
that figure again remains at the same figure,
yeah,
and subsequently again in the July topic paper. The specific point that we're making is clearly that there is a potential for some of these sites to move to contributions through CIL rather than section 106, but it's also the point that those infrastructure requirements may have been updated based upon up-to-date capacity assessments for those types of education facilities, particularly in relation to certain sites no longer having a policy justification to come forward. So that's ideally what we're looking to explore as part of the hearing session today.
Yeah, so I think if I'm just in my simple way of thinking, just put it like this. So I think what you're saying is that the original overall calculation of school requirements for the strategic sites in the Newcastle Point local plan, so in the original IDP, what you're saying is that that figure or that requirement has now been split amongst fewer sites. Is that what you're saying? Yeah.
Yes.
Okay.
But then the additional point, sir, and apologies for jumping in, is that the sites that form the remainder of the site schedule at Appendix 1 of the draft CIL topic paper are listed as various sites within the most up-to-date tables within the July topic paper.
Yeah.
And there is an overall CIL figure attached to all of those sites for each infrastructure type.
Yeah.
But there's no individual disaggregation of what the particular requirements are and how that contributes to specific education, highway, healthcare, and other facilities across the borough. So it's very difficult for us to understand where the assessment work has been undertaken to identify what the infrastructure requirements are,
yeah,
and how the money will be collected from CIL and applied to those various institutions.
Yeah, yeah. Okay. I understand that. Mr. Parton, you have your hand up, and I'm going to ask you to explain to me sort of that paper trail. So if I just look at table 3 of the IDP addendum, there's a figure there for site HO15. How has that figure been calculated? Say the figure for primary education, 272,756.
Sure. So In table 3, if you scroll down to the bottom of the table on page 14, you have the notes that accompany the table, and those notes provide an explanation of how all of the costs are being calculated within that table. And that's the important thing to take note of here and throughout the IDP, is that the contributions have been calculated on a per dwelling basis. So we referred to the original IDP and the projects that were identified for education infrastructure. So while we were able to identify particular projects that the county council may want to put those contributions towards, the financial contributions that we calculated were done on a per dwelling basis. So it wasn't on the basis of this item of infrastructure will cost X amount, so therefore it's split between these sites accordingly. It was actually on the basis of HO15 has X amount of houses. Then we use that calculation on the notes of the table to say, well, therefore it would provide this amount of contribution. And the reason why we did that is because Essex County Council wanted flexibility in how they were going to deliver the infrastructure. So they wanted us to use the calculations that they would make to identify the financial contributions. And while we wanted to provide a demonstration of what those type of projects would be within the original IDP, that didn't transfer to the exact financial contribution. So it's consistent throughout. So in the original IDP, that was table 11. If you refer to the notes on page 28 of that document, you'll see that you've got the calculations there where it would say the per place contributions and what the cost would be and how you would calculate it.
Just let me find that. So table 11.
Yeah, page 28.
Okay.
And you'll see on the notes there, you've got the cost split up for the different kinds of education infrastructure. Yep.
Yeah.
So therefore that
again,
shows
a note at the bottom on how those contributions are worked out. Yeah. Okay.
Yes.
Okay.
Yes, that's right.
So essentially, it's an approach has been taken. It's a per dwelling rate contribution to the different forms of education.
Yeah.
And is the policy then that's irrespective of whether there is a capacity need in terms of the primary school within that area, or is that contribution always expected to be made by sites?
It's the contribution that would be made irrespective of the need for capacity. So yeah, it's a per dwelling calculation, and then the county council would use that to then establish how they would bring forward that infrastructure going forward.
Yeah. And where is the policy basis for that? If I can just ask, now that we don't have the new Castle Point local plan. Don't know whether Ms. Parrott wants to come in on that point.
Yeah, so it would be policy CF1 of the adopted local plan, which expects development to make contributions towards physical and social infrastructure alongside development as appropriate to meet the needs of that development.
And presumably that would be supplemented by the Essex County Council developer contributions guidance.
Yeah, so that's where the calculations are set out. I would just add in the IDP at table 11 and then repeat in the original IDP and then repeated in the addendum. No improvements are required to primary and secondary education on Canvey Island, because actually Essex County Council did identify that there is actually sufficient capacity in that area. So that is actually shown in the addendum. So there has been a sort of look at capacity by Essex County Council in advising us on the IDP.
Yeah. You just follow that through. Yeah, so what you're saying is in that, just taking education, in that table 3 list, what you're saying is there shouldn't be any Canby Island sites making a contribution to education.
Making a contribution towards primary school education or secondary education, because there's actually sufficient capacity within the schools. There is a requirement for early years and post 16 because actually there's insufficient capacity in that area, so they advised us accordingly on that.
Yeah, so where in the table, I'm sorry, it's a bit of a simplistic question to ask, but where in the table it says under primary education, site HO26, which is land at the point, Canby Island, no improvements required in the area, so there's no figure in there. Okay,
yes,
there's no contribution figure. Okay, I understand that. That's very helpful. Mr. Ryder, yeah, I'm sure you want to come back on that.
Thank you, sir. It's just to clarify the point and understand the point about Canby Island in relation to primary and secondary, and I've noted that in the table myself. The footnotes to the tables in the original IDP and the addendum IDP do confirm where no improvements are required, no contribution is sought. Part of the question that I was asking is whether the capacity of existing facilities has been reviewed since the local plan has been withdrawn, because if sites are coming on forward independently, there may be sufficient capacity to accommodate pupils arising from those particular developments. And clearly, cumulatively, there may not be sufficient growth in the area to justify a 1.5 form expansion or a new primary school, for example, in other areas of the borough. So that's just another question of clarification that I'd be grateful for.
Yeah. Okay. Just ask Mr. Parton, Ms. Parrott, just
yes.
to respond to that. Has the capacity of existing facilities, let's call it education facilities, but others as well, been reviewed since the Newcastle Point local plan was withdrawn?
Yes, we consulted Essex County Council on the addendum which we produced, and we've discussed it with them. So yeah, they've done a high level review of the information that we put into the addendum, and we invited them to make amendments if required.
Yeah, Mr. Ryder.
Thank you, sir. Is it possible to request copies or evidence of that communication, because it is quite an important question for your consideration of the aggregate funding gap?
Is that information available, Mr. Barton?
I don't think we would have anything that we could present in terms of evidence. I think it was more through providing them with the documentation and asking them to come back if there was any issues. So I don't think we have any kind of written formal communication that we would be able to provide.
Okay. All right. You have your answer, Mr. Ryder. Yeah. Okay.
So in addition to that question, I'm sure we could obviously refer to the Essex County Council response to the CIL charging schedule consultation, and then the later summer consultation as well. So they had the opportunity to provide comments on that there, and they did respond to the consultation, so we have their representations.
Just as a matter of interest, whilst we're on that, don't want to prolong the discussion, but what did they say?
think it's representation number 9. I'm struggling
Yeah.
to get it on my screen, but if I recall, it just highlighted the issues that they've been having around early years contributions and ensuring that obviously they are secured. I don't think it went into much more detail.
Actually, the version I've got is version I've just called up is not very legible actually, so just bear with me. So the online version is okay.
Yeah, it looks like they've since we've engaged them, they've actually updated the costs for childcare facilities again. So, and that's their principal comment.
Yeah. Okay. Okay. So there's a reference there that I can go to. Okay. I'm going to move off of infrastructure and go on to residential development. Unless there's any further points that people wish to make on that particular question. No? Okay. So it's 10 to 11. I will take a break at 11. If I can just deal with the first couple of questions, I think we can deal with those quite simply, and then I think we'll come back to look at sales values, if that's okay. So in terms of viability evidence under residential development, so this is the second main topic on the agenda, so we'll be working through questions 3 to 8 on this, and it's probably, well, it certainly takes the rest of the morning, probably a bit of this afternoon as well. So question 3, which has a number of sub-questions, is the Castle Point CIL viability study, that's sub 01, document sub 01, submitted in support of the draft charging schedule, is that appropriate for the appraisal of residential development in the borough, with particular regard to the following inputs and assumptions? And then I've asked a series of questions about different assumptions within that document. So I'm not proposing to, I haven't asked any further questions on a number of those, gross to net ratios, densities assumed, phasing, land purchase cost, finance, developer return. I did ask questions on typologies of residential development tested, and also dwelling types and sizes. So I asked on typologies, does the range of typologies tested reflect the type of residential development expected to come forward in the borough and on which the plan depends, and have small sites of 9 or less dwellings been adequately tested? So I've had a response from the council on, particularly on small sites point, as that was raised in representations. I don't have any further questions on that, just to say for the record. So based on the evidence in the viability study and the further evidence provided, and in response to my question, I'm satisfied that the council has tested an appropriate range of residential site typologies, and actually that those do reflect the type of sites that have been referred to as coming forward in the borough, and that small sites of less than or 9 dwellings or less have been tested in both the mainland and County Island on brownfield and greenfield. So I'm not got any further questions on that. I I don't think anybody had any other points to raise in their hearing position statements. So move on to the next question, and it is the same there. So dwelling types and sizes. Ask two questions on that. Does the viability study test a sufficient range and mix of dwelling types and unit sizes as part of the development typologies assessed, and are unit sizes based on the nationally described space standards an appropriate basis for viability testing? So again, I've had a response from the council on both of those questions. I think I'll simply say on this one, I'm satisfied I have enough evidence on this particular question to be able to reach conclusion on that assumption. So no further questions on that matter unless anybody has anything to raise on that particular question. Okay. So rather than getting into sales values now, I'm going to suggest we take a half-hour break. Appreciate we've only dealt with questions 1 and 2, and there's quite a bit to deal with under residential development, but I'm happy we're making good progress. So it's 5 to 11. I think if we can come back at 25 past 11, please, take a half-hour break. As I said, if you can just turn your cameras off, but remain in the session, please, and hopefully by magic a screensaver will come over and remind us that we're on a break. So without further ado, I'll see everyone at 25 past 11. Thank you. Okay. We're ready to resume. I just wanted to clarify the task we talked about earlier in relation to the Appendix 1 list of sites. So just clarify understanding of that. But what I will do is after today, I'll write and just confirm this in writing. But so I'd ask you if you, Code and the council, would work together to revise the list of sites in Appendix 1 of the topic paper, removing the sites that have already got planning permission. The other thing I did want you to do though as well is then for the council to recalculate the infrastructure costs and the funding gap. So that's really where that piece of information is trying to assist me, is just so I can get an accurate understanding of what the funding gap is based on the number of homes that could be delivered or granted planning permission under this the 1998 plan. So that was the second bit that I didn't make clear. Okay.
We had assumed that was the case, sir. So thank you for clarifying.
Okay, great. And I should have said right at the beginning, just to say that there is an icon for Mr. Longhurst on the screen. Just for those who are watching the live stream, Mr. Longhurst is the council's IT expert and is just running the live stream for us. So no need for Mr. Longhurst to introduce himself, but just to be clear, that's why his icon is there. So, okay. So sales values, and I asked 3 questions on this, and I'll just read those out so that we're clear on what we're talking about. So based on, so these are the values that inform or assumed as part of the appraisals, the residential appraisals in the viability study, and whether those values are reliable and based on available evidence. So the 3 questions were, based on the sales transactions evidence that is available, do the zonal boundaries on the heat maps effectively reflect the zonal boundaries in the draft charging schedule? Do they adequately reflect the range of residential values across the borough for the purposes of viability testing? So that was the first question. Second was, is the assumed sales value of £4,150 per square metre for new houses and flats on the mainland, is that appropriate, taking account of the evidence of sales values from residential sales transactions across the mainland areas? And then thirdly, are the assumed sales values of £3,500 per square metre for pounds per square metre for houses and £3,700 per square metre for flats on Canvey Island appropriate, again taking into account the evidence of values from residential sales transactions across Canvey Island? So those are the 3 questions, and I do have what I want to do is deal with mainland values and Canvey Island values separately if we can. And perhaps if you could just have out in front of you the heat maps, and these will be the amended heat maps that were submitted in response to one of my initial questions. There were just some corrections to those so that we're clear. I'll try and make those clear as we go through. So these are figures 3.4 to 3.7 in the viability study, corrected by the erratum. So just sort of taking those 3 questions together, I think, and then looking first at mainland sales values and Canvey Island values. I'm speaking to the council, possibly Mr. Porter, but I have to admit I'm struggling to kind of align the evidence with the sales values assumed in the report. If I can just put that out there, and it'd be helpful if you could explain this to me. But so if I can just summarise what I understand from what you've submitted, and then ask you a question just to sort of explain the differences between the heat maps and the sales transactions data, if you could. But for the mainland, my understanding is that the new build houses values in figure 3.5, so average sales values for new houses. On that heat map, it's only the Victoria ward that sits in the range assumed in the sales values. So there's a sales value assumed in the appraisal for mainland sites of £4,150 per square metre, but it seems to me it's only the Victoria ward or sales in the Victoria ward that actually sits within that range, so 4117 to 4312. All of the others are below that, so St Mary's and Cedar Hall wards or areas, they range up to, or 3,785 up to 4,117, and St Peter's and Boyce are lower than that, ranging from 2,674 up to 3,875. So that's houses. And then if I look at new build flats, figure 3.7 then shows all. It shows the figure for all flats, I think. Yeah. Yeah. Sorry, the figure I'm looking at here is yeah. I think it should actually be figure 3.4 actually, so it should be average sales values for new flats. So if we look at that figure, that shows that St Mary's and St James are both in the proposed CIL range, so they're both within the 4,079 up to 4,567. So their values are within the range assumed in the report, but Boyce and Cedar Hall are not, so they're in the range, in a range below that, 3,590, 4,079. And then if I look at the evidence from new build sales transactions that you've supplied separately for the period 2017 to 2020, that shows that average values are at 4,168 for houses and 4,165 for flats, which on the face of it appears to support the assumed value of 4,150 per square metre on the mainland. So that's, I think, what I'm just struggling to tally up the two sets of figures really, both the heat maps and then the sales transactions averages. So I just wonder if the council could just explain the differences between those heat maps and the sales transactions data, and how significant the differentials are in the sales values across the mainland. Sorry, how the significant differentials in sales values across the mainland, which seem to be evident in the heat maps, how those justify a single value for both houses and flats at the top end, what appears to be at the top end of the range. So I think that's what I'm just trying to get an understanding of, please.
Thank you, sir. I'll have a stab in answering your detailed analysis, which is informative. But I think one of the key things with these maps is that they relate to the average value of a ward. So and in some cases, particularly when we're looking at new builds, you don't have a huge sample number. So we've generally grouped the sample for the mainland rather than necessarily individual wards. The burden of evidence to try and get a detailed assessment, a robust assessment of sales values at a ward level is very, very tricky. So for us, there's quite a clear differential between the two main areas, which are Castle Point in the south, which is Canvey Island, and in the mainland. But in terms of the differentials between the maps, so what we try to do here is do a thematic map effectively, see what the average value is on a ward level. So the values actually within that ward could vary quite substantially as well. But the averages were set down at the rates that we've then grouped into 5 areas. So some wards are going to have possibly, if you looked at one shade, and that the range in that could be quite high, and taking the average of small areas and then trying to build that into another average never really works. So we tend to work on the basis of all the sales values that have been achieved in the mainland, and on that basis is where we set our figures in our report sub 01. We've got it in table 4.7, and that provides the actual value per square meter. And for the mainland, where we had still a range of new builds, which is not substantial, it's close to around about 140, 145, but we found that for houses they were averaging at 4168, and that's across the whole of the mainland. The maps are quite useful just to make sure that we're not going completely off piece by saying that, and also trying to keep, so the maps are useful to sort of see generally where sales values do differ. As you can appreciate, sales values is the biggest impact on viability. It is the bottom line much more than anything else, including build costs. And it's the one thing that does differ around areas. But the overall range differences across the mainland is not so substantial. But when you look at the mainland compared to Canvey Island, there is quite a large differential. And on the basis of the evidence we have and the sample sizes you get for new builds, it was safer for us to say, look, we think you could introduce 2 different CIL rates, because we think, or at least look at 2 different types of typologies with different areas with different sales values based on the mainland overall and Canvey Island as well overall, rather than a ward level. I'm sure you'd see if you did just do an average across all the sites that are in the mainland, they're the figures we're going to get to.
Yeah. I'm assuming that's where the 4168 and 4165 for houses and flats comes from. Yeah. Okay.
Yeah.
Okay.
So I mean, that's and that's just 70. I mean, it's 79 new builds effectively. So yeah, looking at new builds spread out across wards, it becomes quite a.
I thought you said it was at 140 new builds. Sorry.
Sorry, no, it was including flats. It's 100
Okay.
About 140, 67 flats that are new build as well.
Okay.
But saying that, I think with that number over 100, it gave us, not being a statistician, a bit more of a layman on it, but I certainly understand my stats, and generally we wouldn't want to rely on a sample size less than 100 for most averages to extrapolate from, and therefore hence we use the mainland as a whole as an average.
So can I just ask, just as an example, so the thing that sort of obviously jumps out to me is when I look at there is it does vary quite a bit. So if you compare the figures 3.4 and 3.5, new flats and new houses, if you look at Cedar Hall, for example, on new flats, the value is at the lower end of the scale, whereas for houses, it's towards the middle, if not the upper end of the scale. And I suppose my question is to what extent, if you have a scheme, say in Cedar Hall, to what extent can you reasonably model the viability of that on a sales figure which seems well above the average sales, the sales values in that particular part of the mainland? To what extent is that reliable?
I think generally for sort of CIL study, it's very difficult to get down to that sort of level of detail on sales values. Interesting. I mean, we presented the average sales values for the mainland and Canvey at the workshop, and generally people felt that they were comfortable with that. We had no disagreement to those values that we'd added. So there's a bit of sort of qualitative as well, understanding that that they sort of look about sensible for the mainland. You may get differences and dare I say it, and I don't really have that evidence right in front of me in terms of all the sales data to say whether a large part of the new builds have come from the Victoria Ward side. And there may just be a few others in the other locations. So it's that it gets to quite detailed sort of forensics on sales data for new builds. And as I said, there's not been in the last one. We looked at over 3.5 years, and according to Land Registry data, we ascertained probably around about, I think it's probably about 145 actually, new builds in the whole of the mainland. So we didn't really want to get into that level of scrutiny at a ward level. But the map is helpful just to understand where the heavy shades are. And when you look at the map, there is quite a clear difference in the shading between, as I mentioned before, the mainland and Canvey Island, and hence we split that difference down the middle. And certainly you'll get areas, some cheek by jowl, where there's high values, low values. And in some local authorities, I suspect they've not even gone down the whole route looking at differences in areas. They've just applied one CIL rate across, just to avoid undue complexity. Because obviously, the more layers you put into this, it becomes the burdensome of viability evidence becomes really difficult for this sort of level of study. So I think we took a reasonable approach and decided that there's just really two different areas of values in Castle Point Borough, and use that rather than looking at detailed analysis of the wards. But sorry, just to reiterate also the point, looking at the maps, you can see the clear differences between the north and the south, which that to us was a defining line and also easy to demark on a map.
Yeah, no, I understand that. Okay. I don't know whether Mr. Ryder, you want to comment on this. I know you didn't make a big issue of this in your hearing position statement, so no, that's fine.
Nothing from me, sir. Only if Mr. Tatton wanted to make any comments, but I suspect the answer might be no as well.
Sorry, Mr. Tatton, I've been ignoring you.
Not to worry, sir. No, I think there was a table that a spreadsheet table that specifically analysed the limited number of new build values.
Yeah.
And on the basis of that analysis, we concluded that that the figures were within the value of 41.50 per square metre was appropriate in relation to new build on the mainland.
Yeah. Okay. Okay, thank you, that's helpful. And then if I can just turn to Canvey Island, so different, I think a different problem here. I perhaps won't give you the same detailed analysis for Canvey Island, but in essence, my understanding is that the new build sales transactions evidence is too limited here to provide a reliable data set. And so what you've done is base the sales value on assumptions about the existing stock and applied a premium to that. So applied a 20% premium. And I think that's the question I wanted to ask. So yeah, so you set two values, one for houses, one for flats for Canvey Island. Yeah, so 3,500 per square metre for houses, 3,700 square metre for flats. Base that largely on sales of existing stock or transaction values from sales in the existing stock. So that was my question firstly to the council. Are existing stock sales values a reliable basis on which to assume new build values? And is a 20% premium on top of existing sales values a reasonable assumption to kind of estimate a new build sales value? And if so, why? I mean, I'm sure you'll say yes, it is, but why is that a reasonable assumption?
Yes, thank you, sir. Really, as you can understand and appreciate, again, the sample in terms of available evidence is quite small for new builds on Canvey Island. We had 9 altogether. I believe there's a lot more now. It's growing. There's certainly more interest in Canvey Island from developers, but at the moment we have to use the evidence that was in front of us. So we couldn't rely on 9 values. It was just, you know, they can be heavily skewed by 1 or 2 outliers. So we decided to dig a bit deeper onto the data we had to show the differentials by ward, which is based on second-hand or existing houses and flats in Canvey Island, to just make sure that whatever value there is, that should give us a good indicator. But what we do know is that, and I think pretty much nearly most studies I've ever worked on, when you look at new builds relative to existing units, there's a premium. And the reason there's a premium is obviously you're getting a new product. There's quite a strong demand for new build products. There's sometimes advantages in buying a new build from things like stamp duties, etc. But the or Help to Buy and things like that has helped as well in the past. But overall, though, when you look at the sales values for new build relative to existing, you get about a sort of 20%, sometimes a lot more than that, improvement in viability. So we decided on the evidence that we had in front of us to apply a premium. Had we not, and had we just relied on existing values, then we're at risk really of putting the council with a disadvantage, because we know, I mean, there's sometimes a degree of logic to some of this, and the logic is that new builds do generate that bigger value, and we would have been undermining the viability and deliverability of sites to afford a sale rate. So it was for us appropriate, and we set that out. That's what we've done. We've applied a 20% premium to reflect that.
Okay. Again, I don't know whether Mr. Tatton, sorry, Mr. Marshall, please come in there.
Oh, that's okay. I just wanted to clarify just on that 20%. That is the difference. If you look at the new build and existing values in the mainland, if you find out the percentage change between those, that equals 20%. So we've applied the corresponding difference in the mainland to Canvey Island, because we've got a wealth of data in comparison on the mainland compared to Canvey Island. So it is based on something.
Yeah. Okay, thank you. Mr. Tatton, did you have any comments on that as an approach?
I think I did have a query which Mr. Marshall may just have answered. It was relating to if you, without knowing the composition of the existing housing stock in terms of dwelling size, if you take a £1 per square metre rate from that and then apply it to an NDSS compliant dwelling, are you overvaluing based on a comparison on the number of bedrooms rather than strictly the size? I think Mr. Marshall's answer, based on the analysis of the premium in relation to new build, addresses some of that, but obviously we've no idea that the new build comparables were themselves NDSS compliant. So there is the prospect of some sort of house price inflation being applied in that process.
Mr. Porter, yeah.
So for the floor space, hence the reason we use a £1 per square metre in the sales values. One is because obviously when we set in the CIL rate, it's going to be on a £1 per square metre. But very importantly, as Mr. Tatton said, the house size does make a huge difference in the value you're going to get. So a large flat compared to a small flat, there'd be a big price differential. So we're sort of aware of that, and therefore we've taken the actual sales values for each property and the size of those units based on their energy performance certificates, which are also submitted as part of a new build. It's quite an extensive exercise to do, but it was our best way of making sure we're very robust on the average sales value per square metre. So actually our sales values reflect the total amount of sales across all new units that have been sold, and the total amount of floor space that's been sold, and then divided into two, so we get the average for them. In terms of NDSS sizes, we also looked at the sales, the sites themselves, the houses that had been sold and their average unit sizes, and compared that as best we could with NDSS sizes. And what we generally found was that most houses were building, most houses, new builds and existing, were built at a bigger size than what we're using in terms of NDSS. Not all, but on average, they were generally bigger. I think we set that out in our report and explained that as well. I can refer you to the relevant bits, but and on that basis, if anything, we may have erred on the side of caution because we've assumed possibly a house of size or flat size that's slightly smaller than what's been delivered in the marketplace. And obviously, if it's slightly smaller, one, you get a higher per square meter value because generally you find the per square meter values increase as you as for the smallest units than they are in bigger units. Because, but also we found that if you've got less floor space assumed on your site, which are typically densities about 35 dwellings, it's based on the amount of floor space you sell. So we may be slightly undercosting or undervaluing some of the sites for that reason. So we sort of err on the side of caution. We needed something to, as you can understand, for this level of study, we have to do an average across lots of things. And the best approach to us was that going forward, as I'm also aware of, most house builders now are meeting the national space standard sizes anyway. So we've just taken the very bottom end of that national space standards for these units. And actually, in terms of the report, it's table 4.4, where we've compared the sizes of units that have transacted and sold, both new build and existing, and as a comparison, what that might look like against the NDSS sizes. Without getting too detailed on this now, but there is a slight difference in that some judgment has to be made because the way that land registry data is reported is on a terraced, semi-detached, detached house, whereas the national space standards and our viability model is based on number of bedrooms. So there's a broad assumption that a 3-bed house be semi-detached, a 4-plus bed house be detached, etc. But it gives you some degree of comparison as best we can in this sort of work.
Okay, well, that's very helpful. Thank you. Okay, is your hand a legacy hand, Mr. Porter? Yeah. Okay. Let's move on to affordable housing sales values, please. So by that I mean affordable housing transfer values. So this is part D of question 3, and the question, I asked 2 questions on this. Firstly, are the assumed affordable housing transfer values of 50% of open market value for affordable rented units and 67.5% of open market value for intermediate or shared ownership units justified by the evidence, taking account of the council's answer to my initial question 9. So that was the first question, and then the second question: what would be the effect on the appraisal outputs of applying transfer values at the average rates of 48% and 65% respectively, drawn from the stakeholder questionnaire responses? So Those are two questions I've asked. In response to that, the council has helpfully undertaken that analysis, so applied those average rates and reappraised the residential typologies based on that. So my understanding, what you said, what the councillor said is transfer values of 50% and 67.5% for affordable rented and intermediate shared ownership are reasonable, and you say they compare favourably with values in Plymouth, South Hams and West Devon, and you set that out in your hearing position statement, and you tested but nevertheless you tested the average rates of 48% and 65%, effectively the results of that are that they mainly affect brownfield site viability. I think they make 3 brownfield typologies on the mainland unviable, and all except 1 on Canby Island unviable. Yeah, and then you also elsewhere refer to the fact that, of course, under the 1998 local plan, a lower affordable housing requirement is likely to be achievable because there's no longer a policy requiring 40%, but you tested on the basis of 40% of the dwellings would be affordable. So that's my understanding of that. And yeah, so Code, you have picked up on 1 or 2 points on that, particularly around the value for the open market value for social rent, and I'll come back to that in a moment. You've also picked up on whether the evidence from the stakeholder feedback was from developers or registered providers. So, and again, we'll just come back to that. But can I just ask the council, just in terms of your suggestion that 50% and 67.5% compare favourably with values in the southwest? I mean, how comparable are they really? Different parts of the country. Yeah, I'm not convinced that they're comparable. Convince me.
Yeah, for sure. Sorry. So only because that question arose at the time when we've just done a survey of registered providers in a certain area of the country, in the southwest of England. Generally, though, we find that where we've approached RPs here, we've not had the evidence, and the evidence hasn't come back to us. So we need to use some available evidence. And we've drawn really from our own experiences. We do a lot of 106s as well as we do a lot of these studies around the country. And generally, we use values typically, I'm afraid, higher than 50% for affordable rented. May have erred on the side of 50% here at the lower end, partly because of the information we asked for from the developers. And same for 67.5%, which I think is generally about right for most shared ownership properties. Just to explain, though, the figures we use in our report for the viability and CIL setting is predates our work in the southwest. So it was actually informed by our work from elsewhere, and it was partly informed by the survey we held. We did send it to registered providers. We sent it to local developers and to give us their feedback, and it's not substantially different to that. I think maybe Mr. Tatton in his own note explains a little bit as well why the 50% for affordable rented is a little on the low side, because there's a degree of confusion about affordable rent, and often it's seen as being social rented.
Yeah.
And we had some low figures, so that the average itself for that came out, I think, 47.5%, something like that. But if you discounted any skewing because of the interpretation, yeah. So 50%, I'd say is high, not high, is appropriate, but if anything, is slightly should be higher, because elsewhere we're now looking at probably 55% is more appropriate for affordable rented type products.
Okay.
And shared ownership, again, you're able to market can rent it up at 80%. So its value is, if anything, could be up to equivalent to that, but we know that it's not always achieved, and hence 67.5%. But again, we use 70% quite often elsewhere. Very rare do we see it much lower than that, except for possibly in London.
What's the position on grant aid at the moment then in terms of affordable housing? To what extent is social housing grant, I'm sorry, I'm not sure whether it's still called that, but to what extent is that available to support market-led schemes?
Yeah, so we've assumed that there's no grant available, and particularly outside of London, there isn't any grant available for S106 sites.
Okay. Even if they're being, the council is seeking a social rented tenure.
That's my understanding, so yes.
Right. Okay.
Including social rented. The reason we don't overly focus too much on social rented is because it does come down to viability, and it doesn't. The planning policy doesn't specify that it needs to be social rented. Obviously, most local authorities have a wish for some social rented because it makes it much more affordable for their residents. But all we know is that there's a split of about 50% to be affordable rented, which could be a combination of social and affordable rented. But if viability is an issue, if there is a CIL in place and they can show that that's an issue, then there's going to be obviously a flexibility on that particular point of tenure because it's not specified in the local plan policies.
Okay. We'll come. I can see you got your hand on, Mr. Tatton. We'll come back to that point I think you've made in your evidence. But Ms. Parrott, did you want to just clarify that?
Just in terms of the availability of grant, my understanding is it isn't available on the Section 106 compliant element of any affordable housing provision. So if the requirement is 40% and a developer, or probably an RP, is looking to provide 100% affordable housing, then the grant would only be applicable to the 60% that would normally go to the market.
Yeah, okay. That's fine. Mr. Tatton, do you want to add something there?
Yes, I was just raising my hand. It was, as Ms. Parrott's correctly pointed out, the position with regard to what Homes England refer to as additionality. But those rules would also preclude, if there was a policy requirement for affordable rent at 80% of market rent, they would not fund the conversion of that to social rent at a lower rent. So I just wanted to put that point across.
Yeah. Okay. Okay, and yeah, so Mr. Porter has clarified that the evidence referred to from the stakeholder feedback was actually from developers, not from registered providers. But presumably that doesn't come as you, Mr. Tatton. Presumably that doesn't negate the value of that evidence if they consulted on or asked for evidence of affordable housing transfer values, and that's coming from a number of developer sources. Why should that be evidence of less value?
My understanding is that the stakeholders' responses were from 4 parties alone.
Yeah.
As you say, it didn't include any registered providers.
Yeah.
I think there are 2 aspects to bring to your attention. Firstly, was in what have been quite an informal discussion, a lack of clarification around what assumptions the parties were being asked to make in terms of definitions used for certainly affordable rented housing, and whether those assumptions were applied in relation to social rent or affordable rent, and as sometimes can be the case, affordable rent subject to further restrictions or caps on value in Section 106 agreements. Secondly, we don't know from those parties' experience, given there has been extremely limited development in Castle Point, certainly amongst major house builders, who I understand form the bulk of the stakeholder responses. They were probably giving, stating their opinion from a much more wider area, not specifically focused on Castle Point. And thirdly, there is this confusion with the wording of the now withdrawn policy H04 in the local plan, which referred to affordable rent, and I say that in lowercase letters, referring to the MPPF, which itself then splits between social rent capitalised and affordable rent capitalised. But the policy said that it would seek 50% affordable housing for rent as defined in the MPPF available to those in need of social housing. So it could be construed that is social rent. So I just, as a sort of off the cuff reaction, as what I understand the consultation with stakeholders consisted of. It's not clear they were able to make a very considered judgment.
Yeah, no, I understand that. I was just looking for the note that attached it to your hearing position statement. Actually, my apologies. I did have a read of that. The note on policy H04. Well, I'd be interested in the council's view on that actually, but I didn't read it necessarily as meaning social rent. I mean, it seems to say affordable housing for rent as defined in the NPPF, which, as you say, includes both, doesn't it? So that, perhaps, Ms. Parrott, you could just give me an answer on that particular point. That policy clearly isn't in place any longer, but what is the council's policy in respect of affordable housing for rent?
So, as you say, policy H04 fell by the wayside at the withdrawal.
You're just a little quiet, actually. I don't know whether you can.
Sorry, it's my position on my mic.
That's
policy H04 is no longer applicable. It was not adopted by the council. It was part of the withdrawn plan. Yeah. So policy H7 of the adopted local plan applies. I'll just flick to it to make sure I'm correct in what I say. Sure, yeah. And it does not set out any specific split between affordable, rented and ownership, which probably isn't surprising, bearing in mind it's from 1998. We do have a developer contributions guidance SPD, which is dated 2008, which does seek to identify a split, but that's in the process of being updated at the moment. It was due to go to the draft was due to go to cabinet tonight, in fact, but unfortunately we couldn't have the scrutiny session on that because of the Queen's passing. So we had scrutiny on that last week.
Just answer me on that though. Just answer me on that. Does in that SPD, what do you assume in the definition of affordable housing for rent? Are you assuming an element of that will be the social rent?
I'm just getting it up at the moment just to check that out. You got it, Mary?
Clearly, both comply with the NPPF definition, but it goes to the centre of the point about whether a 50% affordable housing transfer value is reasonable.
So
affordable rented accommodation.
It refers to the definitions in the national policy, which was obviously PPG. free
So,
at the time. So clearly, that's why we're going through the process of updating it at the moment. But again, we would in the updated version, we'd also be looking to refer to the definition in the MPPF.
yeah. Okay, which of course includes both social rent and affordable rent. Yeah.
Yeah.
So I'm not sure I'm any the clearer on whether the assumed 50% of open market value represents a reasonable assumption for the types of affordable housing schemes that might come forward in the future, if they might be a combination of social rent and affordable rent. I don't know whether Mr. Porter might be able to help on that, and I will come back to you, Mr. Tatton.
So other than to refer to what I mentioned earlier, that if at the moment, my understanding was particularly when this evidence was also put together at that time, which is also when we used the sales values and the build costs. So a lot of it, is got to be fixed at that point in order to us to set a CIL rate and inform that. Yeah. But at that time, there was a policy requirement that was ambiguous in terms of what the affordable rent would be, or the rented affordable housing should be. So, as I mentioned, if there is a high proportion requirement for social rented, and that scheme could no longer would be viable and able to deliver, then if anywhere there's flexibility, it's going to be one in the affordable housing rate, and preferably at the start it'll be in the type of affordable housing you have, because obviously affordable rented is of higher value than social rented. So without prejudice to what the council may say, but my own experience of 106 negotiations is that's where the local authority will move towards, would be to remove the social rented and ensure there's more affordable rented. And again, sometimes what you tend to find is that you reduce down your rented altogether and you become more shared ownership, and then you start looking at things like affordable housing rates. So I mean, there are various scenarios. I think, as you said, I think we feel that 50%, which is at the low end of affordable rented anyway, so you could arguably, I'd say, support degree of social rented in it, has been tested to inform the CIL rates.
Yeah. Okay. Ms. Parrott, was there anything further you want to say? As yours a legacy hand? Okay.
There was just an issue, obviously, around first homes as well, insofar as.
Sorry, we'll come back to that. We'll come back to that. Sorry, yeah. I brought you in prematurely. Mr. Tan, did you just want to come back on what Mr. Porter has said and the explanation as to how the SPD feeds into policy H7?
Well, I think it just refers back in general to the uncertainty regarding the status of the relevant plan. If these matters aren't statutorily defined, applicants will struggle to comprehend what is being requested of them.
Yeah.
Mr. Porter's response seems to imply the council has great flexibility to move the goalposts around wherever they see fit.
Okay.
I think so. I mean, just to add to the comment is, again, experience from most local planning examinations is very rare that you'll ever get a definition how much of social rented there will be within the affordable housing requirement. Quite often it's just the affordable housing is required and that's the rate. Then the tenure mix will be dependent on schemes, as it generally is, because you don't need certain sites won't won't have a requirement for social rented for good reasons, that they're not appropriate types of houses.
Yeah. Okay.
A lot of flexibility.
Okay. Thank you. I'm going to come back to Ms. Parrott now on first homes. Well, Mr. Tatton, you still had your hand up. Mr. Tatton, you still have your hand up. Was there something more you wanted to say on that?
It was a legacy hand, but it was not wanting to take anything off Ms. Parrott. Mr. Porter's comments regarding around policies not specifying individual tenures, whilst there may be some policies that have been adopted on that basis, I wouldn't consider it necessarily good practice. When you read the First Homes PPG guidance, that specifically says first homes should not prejudice the amount of social rented dwellings to be provided, which can be construed as indicating that policies should specify those targets.
Okay. All right. Thank you. Ms. Parrott.
I was just going to add that first homes, they're obviously required for 25% of the affordable housing supply, but there's also the separate requirement in the MPPF that 10% of the units on site are for affordable home ownership. So kind of overlaps with the affordable housing requirement overall to some degree. And given the site mix that we have, which is a lot of smaller sites, we're likely to see first homes delivered, particularly as for the affordable home ownership element of schemes in flats and so forth, because they have no there's no middleman that deals with the leasehold arrangements. And obviously the national position on that is 70% in terms of their sales price compared to market values, obviously capped at a certain point. So that obviously has a bearing on the open market value and the affordable home ownership element going forward.
Yeah, typically, what is the proportion of first homes that you are looking at on schemes then that schemes that are currently going through the planning process?
So we've had a couple of schemes come through the process where they were brownfield sites, so there was vacant building credit and so forth. Because the units would be in a leaseholder arrangement, we've secured first homes for the entirety of the affordable housing supply as opposed to taking a contribution. Elsewhere, we've taken financial contributions in lieu of on-site provision on those schemes, and then used that along with right to buy receipts to provide affordable housing on council-owned land.
Yeah. Okay. Okay. Yeah, Mr. Tatton, just make this the last contribution on this particular issue.
Yeah, it's just in response to Ms. Parrott's comments regarding first homes. Obviously, we've got no question that the receipt to the developer is greater at 70% of OMV compared to the 65% OMV intermediate assumed in the viability study. But there are obviously additional costs borne by the developer in terms of sales and marketing, and also they carry the sales risk. So potentially that would warrant use of a higher rate of developer return in any appraisals.
All right, thank you. Going to move on to build costs. Now, I'm conscious that it was Simon Holmes who I think had raised a question about the build costs assumed in the viability study, and they're not here, but I'm happy for either Mr. Ryder or Mr. Tatton to speak up on this point, but I did have a question for the council on this. So if I deal with build costs, which is question 3E, in two parts, we'll deal with the median or lower quartile BCIS figures. I'm sorry, Mr. Ryder, you did have a view on the second part of this question in respect of Part L and Part S of the building regulation. So we'll come to that shortly. But in relation to question 3E1, the question is, should the build costs assumed for larger scale residential development be in line with median or lower quartile BCIS figures? And the council's view in brief is that for strategic sites developed by volume house builders, lower quartile BCIS costs are relevant because the median figures don't reflect the sort of economies of scale that volume house builders can achieve on larger schemes. And you say that the lower quartile figures for large sites were presented to the stakeholder workshop with no objections. Yeah, and you said it's common in other CIL examinations and appeal hearings that lower quartile figures are used for large sites. So the concern I think raised by Persimmon is that build costs for large sites should be based on the median BCIs, really because of higher labour and materials costs in Castle Point. Well, I haven't specifically got the evidence for that, but and also potentially the higher cost of building on Canvey Island. I think they made reference to the the higher design requirements for flood resilient units. Yeah, and I think they also make the point that the VS is relying on build cost data, which hasn't been updated for a year. So I think my question just to the council on this, sort of try and keep it fairly simple, is you'll have read all of that from Persimmon. I'm just interested in how the higher labour, materials and design costs and the effects of inflation on build costs over the last 12 months, how those factors are taken account of in the viability evidence that I've got before me.
So we undertook some sensitivity testing when the study was prepared. It was a general sensitivity testing, and we like to use was what would happen if 5% increase in build costs without any other changes, and similarly a 5% reduction in sales values. On the other side of that, certainly build costs have changed. They change on a monthly basis. We have to fix it at some period in time, otherwise it becomes impossible to look at. So we fixed it when we did it. So they're the build costs we used, and they match the sales values at that time. I think in our response to your notice on sensitivity testing specifically, we did have a look at what's happened in 12 months prior to July when we was responding to these questions, and we was able to get that from the BCIS. So that's the build cost data by RICS, using their tender price index increases, and at that time it showed that they had grown by about 9.1% actually for Castle Point in the 12 months to actually to May 2022. And similarly, data we had, albeit slightly different, on sales values to July, because we had best available evidence that shown that sales values in the 12 months of July was 13.3%. So actually the impact of the build cost increases was not only negated by sales values, but actually I think the difference is much bigger, because sales have grown, partly because sales values base value is it's almost twice as much as build cost, and when they've grown by 13% on the base compared to build cost, which is lower, and that's grown by 9% on the base, we felt fairly assured that if we were to retest this now based on current costs and values, you'd only get a better viability outcome.
Yeah.
And just so going back on, I think the point made by Simmons was, well, he said in terms of the build costs in Canvey Island, all our build costs are rebased to the Canvey Island values. They are quite considerably above the average already in terms of, if you look at the UK build costs. Build costs don't vary too much. You get some small differences by region, unlike sales values that does vary a lot by area. But build cost generally is very much the same for a price of building a house, no matter where you build it. But in Canvey, it was something like 7-8% higher than the average. But so we've already allowed for the build cost differences in Castle Point by rebasing it to the BCIS for Castle Point. And in addition to that, we've also allowed for some additional costs on build costs to allow for any potential extra requirement for meeting flood risk. So coastal flood risk particularly, we added, typically it's around about another £10,000 per unit. It's £120 a square metre we added on top of the build cost to allow for that potential. which won't be the case in all sites, but it may be for some. So I think that we, as a study, we had looked at that in much more detail than than typical for this sort of high level study.
Just point me to where that is in the viability study. Would you mind?
Sure, sir.
It's 4.43 to 4.44. So
thank you, Tom.
Thank you. Thank you. Yeah, so it's part of exceptional costs, yeah. Okay. Thank you. I'm happy if Code wants to come in on that point. If not, I was going to move on to question 2. Did you want to come in, Mr. Ryder?
Again, sir, sorry, nothing from me, but just depends if Mr. Tatton wants to comment.
Mr. Tatton, you're back. Sorry, you were temporarily, screen was temporarily on, so I wasn't sure whether you were engaging.
Yes, apologies, sir. No, I think in terms of our representations, I suppose we were happy with the use of BCIS lower quartile costs as being representative of volume house builders, but I think we're just acknowledging that in the use of such costs in a viability study then becomes a self-fulfilling prophecy that only such sites can be developed by volume house builders, and it's rather antithetical to diversifying the producer base in construction. So
but I think, sorry, I may have missed your point there, but I think the lower quartiles only apply to larger volume schemes, not to smaller or medium-sized schemes. Was that what you were going to say, Mr. Porter?
So yes, we only applied it for any sites with more than 50 units. And as we know, volume house builders tend to build at 50 plus units. Anything with 50, if anything, it could probably even be a bit lower than that. But we set 50 as a point, a threshold for applying that. Any site below that, we took the median.
Does that help, Mr. Tan? Or have I misunderstood the point you were making?
No, I did understand that point. I was just commenting that it does restrict the number of players who can engage in development of such sites if the costs are modelled on those that are representative of volume house builders.
Right. Okay. Okay, thank you. We'll move on to question 3E2, which is in the light of the Council's answer to question 10 of my initial questions, which is about the changes to building regulations in respect of energy efficiency and conservation of fuel and power, and also electric charging vehicle points. What effect would the changes in the building regulations in those areas have on construction costs, which were assumed in the viability study for residential developments and then on the resultant headroom for CIL? So that was the general question asked. Council, you said in response that in respect of just dealing with electric vehicle charging points, that an allowance of 976 per unit was included in the VS, in the viability study. I just couldn't see that in there, and wondered if you could point me to that.
So sorry, I also picked that up, and I realised that that's a mistake. Actually, it wasn't included because when we undertook the work that was published last in August 2021, there was no announcements around electrical vehicle charging points nor changes in the building regulations. So sorry, that is an error.
Okay, so
how
does that impact then that sort of charge per unit now that it's part of building regulations?
Difficulty is that requires retesting everything, but in terms of what we tried to do, and I'm trying to understand this, was looking at what the government's been saying about its impact on the market and what the market can deliver. They've undertaken an assessment themselves, which looks at Part L changing building regs and give us a figure, and then we've used that to deduct that extra cost from what we consider to be an appropriate CIL rate, and it reduced those costs down slightly, as you'd expect, to allow for that. But the key thing is, and I think going back to early guidance on any of this, is that there are changes that will happen, which won't always been assessed in our work, which is why we have a buffer. And so we looked at the headrooms, and we took a considerable buffer for most sites of at least 33% to allow for those unexpected costs that could occur. So we would argue that we would see that just maybe being carried through in terms of the buffer for the sites.
Yeah. So you're saying, sorry.
As well as the other general, we've got another 5% as well on contingency for building costs. So if those extra costs are incurred, they would be covered quite easily within the contingency that's been allowed as well.
Yeah. And you say that's the same for costs associated with the changes to Part L and Part F of the building regulations. You said that DLUC estimated the cost of that will be about 3,800 for a semi-detached dwelling and 2,090 for a flat. Again, so you say that the 5% building cost contingency and the buffers provide sufficient scope to absorb those sort of increasing costs.
So yes, but unknown costs at the time of the study, that's where we allowed for. So yeah, these are certain costs that would potentially come through now, and subject to any announcements that are made today by the government. But we understand that they're the sort of thing that the buffer's there for.
I just ask Code, Mr. Ryder, Mr. Tatton, what your view is on that approach then, the use of the 5% contingency and buffers to accommodate those sort of additional costs.
I'll take that if it's okay, sir. There's no strict definition of what should or shouldn't be included in a contingency allowance. However, I would expect the use of a contingency allowance to deal with unforeseen site circumstances, rather than a general underlying statutory requirement to construct to a prescribed standard under the building regulations.
Okay.
I was just checking the chronology. Although the final stage impact assessment by DLUHC was December 21, which will be after the last CIL viability study update. I believe there were some preliminary studies in advance of that which did have forecast costs, so they could have been incorporated into the viability study from the outset. And I think the other question is, whilst these changes to Part L were flagged well in advance, and to some extent the requirements or the targets were known, even if the methodology of how to achieve them wasn't, we still got another step change on the horizon in terms of the Future Home Standard, which, as it stands, is still scheduled for 2025. It's the extent to which those additional cost increases should be factored in, given the longevity of the CIL charging schedule.
Yeah, I mean, coming back to you, Mr. Porter, I mean, you do see future homes costs factored into viability appraisals. So I'm just interested in why that wasn't factored in.
Partly, sir, because there's certainty, and we don't know what's actually going to be in the 2024-25 Future Home Standards changes to building regulations. We don't at the moment. We certainly didn't know year and a half, 2 years ago when this work was undertaken. So hence we have that buffer for those potential unknown costs. There's also, I mean, again, there may be changes, as we know in government changes at the moment, all sorts of things are happening. So there's definitely no certainty over that to allow for it. But I think the main thing is that's quite far ahead as well. So CIL studies, generally in guidance, we're looking at should be reviewed on a regular basis. So regular sort of in 5 years. So if there, and also if there's a substantial change to the economy, then maybe we looked at it again. So for now, though, we based everything on current costs, current values, as set in the Harman report in terms of early guidance on assessing CIL, and that's why we used what was known and at that time and allowed a buffer to be allowed for that. I think on contingency, there's some debate as well about whether that should even be fed into an appraisal of this sort, because it's high level, and contingency, understandably, when somebody's making an investment and they write their own viability assessment, they are building those extra worst case scenarios. But a high level strategic study like this, costs could go up, but they could also come down. So at the moment, we've erred on the side of just costs going up and making some allowances for that. There are some studies, particularly ones I know prepared in Canterbury and places like that, by Three Dragons, where they don't even apply a contingency for this sort of high level strategic study for that reason. But we still allowed an extra 5% on build costs and externals as to replicate what an investor might do on a specific site, rather than necessarily you do for a strategic study like this.
Yeah. Mr. Marshall, do you want to add something? Sorry, you're muted, Mr. Marshall.
Sorry, I was putting my hand down and then I forgot to unmute myself. Apologies. No, I just wanted to just read out a quote from the RICS guidance on contingency, just to say, which is in their valuation of development property, a higher contingency allowance should be compensated by a relatively lower rate of return. And just point out that we actually haven't done that in this case. We've got a fairly high figure for contingency, and we've got a fairly high figure for profit at 20%. So when Mr. Porter's talking about these kind of checks and balances in terms of contingency and a buffer, it's probably also worth keeping in mind our thoughts on profit as well, I think.
Okay, thank you. I'm going to move on to external works and then professional fees. So on external works, so this is question 3F in the main issues and questions. Question I asked was, is an allowance for the cost of external works equal to 10% of build costs justified by the evidence, and taking account of Council's answer to my initial question on this point. And again, it was pursuant really that put forward, so the Council has assumed 10% plus an allowance for garages on some typologies, which you say equates to around 15% for external costs. Then once that the allowance for garages is added on for certain types of development, so 10 to 15%. Then Persimmon are arguing it should be 20% of build costs and quoting an examiner's report from elsewhere in the country. So I mean, I'm broadly satisfied that I've got a range of evidence here, and I don't really need to pursue it in any more detail. I understand the respective points and the evidence backing those. So I'm satisfied I've got enough on external works, but I didn't want to deny any opportunity for further discussion on this point. Don't know whether Mr. Tatton or Mr. Ryder, you had any comments on this? No.
Apologies, sir. No further comments on. We didn't object to the use of the 10% allowance, but we did have objections to the opening up costs. So to the extent to which the 10% allowance relates to normal site development works, we were in agreement, but we felt that the strategic site we represent should have a much larger allowance for the infrastructure costs.
Fine, we'll come on to that as site costs. I've got it labelled as, so we'll definitely pick that up. Okay, thank you. Okay, so moving on to professional fees. So question 3G. Question is an allowance for professional fees equal to 8% of build costs justified by the evidence taken account of the council's response to my question 12 of my initial questions, and that response set out a range of evidence that council has used to base that 8% allowance on. Now there was there's concern raised by Persimmon, and not here for to press this any further or for me to ask my question of them on, but my question was going to be that they say that an 8% professional fee isn't properly justified in the viability study, but the council has, it does seem to me that council has applied a range of survey and appraisal evidence which suggests that 8% is within the reasonable range. I was going to ask what evidence they had to support the 10% figure. I'm not asking you necessarily to come in on this, Mr. Ryder or Mr. Tatton, if you don't want to, but I just wondered if you had any comments on that professional fee allowance. Maybe you just tell us what you said at the consultation stage on this. Is that Mr. Ryder?
I was going to defer to Mr. Tatton, but I do apologise if Mr. Tatton's not expecting that.
Hospital pass to you, sir.
Yes, I wasn't representing our clients at consultation stage, so I wasn't party to those stakeholder discussions. I would contend that both rates could equally be applicable depending on the individual site in question.
Yeah.
The council's obvious figures obviously erring on the conservative. Persimmons are not necessarily, in my view, unreasonable, but I don't know the particular reasons they would have to support that claim.
Okay. All right. Well, I'm aware of the other evidence around that, and the evidence in the Harman report, which is now a little dated, but nevertheless provides an appropriate approach to these things. But that's fine. Okay. No further questions on professional fees. I didn't have questions raised questions on contingency or abnormal or exceptional costs. And there weren't particular representations made by code on those, but I do want to come on to site costs. And if we can deal with this before lunch, that would be good. So this is question 3H, which was do the site opening up costs for the strategic sites tested in the viability study reflect the site-specific costs identified by site promoters and developers? I think this does pick up particularly on a concern raised by code about the assumption in the viability study for site opening up costs for the site that you're promoting, HO13, where the viability study has allowed a figure of 10,989, so nearly 11,000 per unit, but you say the figure should be £25,000 per unit. I think you say you weren't present at the meeting where this figure of 10,000 or close to 11,000 was agreed, and I think I just want to try and get underneath this the figure that you put forward. So if I can just say, it seems to me the viability study does put forward a range of allowances for site opening up costs for greenfield sites, so ranging from 6,000 to 22,000 per unit. Although on the strategic sites like yours, they say it was informed by evidence from the site promoter. So I just wanted to understand from code, probably Mr. Tatton. So you're maintaining that allowance made in the viability study is insufficient and that 25,000 per unit should be what's allowed. Taking those at face value, if I just say, OK, that's the difference between you, would you say that the viability headroom in the VS appraisal for site HO13, would you say that viability headroom allows sufficient scope to accommodate the difference? I don't know whether you want to perhaps bring that up, and I'm conscious that you have an alternative appraisal, which we will come on to discuss. And so at the moment, don't particularly want to go through the alternative appraisal, but just in terms of the viability headroom identified in the appraisal for site HO13, don't know whether you have that up in front of you. And there is a headroom for CIL of something like £641 per square metre, which from my sort of rough calculations comes out at about £35,000 per unit, is a rough calculation from my understanding of the headroom. Yeah, so I'm just interested in whether you think that difference can be accommodated by that headroom.
So I believe our comments were that it doesn't diminish the viability of the site per se, but becomes a contributing factor when added to other concerns and potential fluctuations in market values and build costs.
Yeah.
As I say, I might defer to Mr. Ryder for the specifics. Our client maintains that no one within the organisation currently was present at that meeting, and they've not seen any record of a minute to indicate who put the figure forward. But I think if you look at the CIL viability study, table 4.11 sets out a range. Yeah, 4.11 sets out indicative cost depending on size of site.
Yeah.
So for sites of between 200 and 499 units, there's a cost of 15,000 per unit. which goes up to 22,000 of sites over 500 units. Now, what is odd about the figure that's advocated for site HO13 is that it's below £10,989. It's less than the allowance for sites of between 200 and 499 units, even though it's 455 units.
Yeah.
So we're not sure why that was picked. We presume that must have looked anomalous to the consultants at the time, but it wasn't picked up on. We acknowledge our clients haven't got a detailed cost estimate for the opening up costs for this site. It is only based on comparison with other strategic land opportunities they're involved in of a similar scale, and a direct comparison that's been drawn.
Can I just ask what is included in that figure? What do you define as site opening up costs?
It's the everything that isn't included within the development. What is standard and what is abnormal is always very hard to define, but within the footprint of the estate development works, it's all the additional costs in terms of site services, infrastructure, connecting highway infrastructure, services upgrade, utilities. That's not an exhaustive list, but that's what I'm trying to say. Everything over and above what goes into what would have been a standard estate development scheme.
Yeah. Okay. Thank you. Mr. Porter, yeah, I'm going to ask whether you've got any comments on that, the question generally that I asked, but also where this figure of 10,989 came from.
Thank you, sir. So we sent site promoters a questionnaire at the beginning where we specified what their assumption would be for certain costs, and one of those was strategic site costs. So that was the figure that we got back from the site promoter when that survey was sent. I was just, while we're talking, I don't have it in front of me, but I can try and dig that out if you like. I just also want to raise the point, and I can understand there may be some not fully appreciating this, but even that figure, when we asked the developer what that figure would be, it would be infrastructure on site to open up the site. So, as Mr. Tatton said quite rightly, similar sort of infrastructure. But in addition to that, we've got another £25,000 a unit that came from the infrastructure development plan for that specific site, and that will cover things to do with maybe bringing access to that site, possibly potentially opening up key routes onto the site, which is often what strategic infrastructure costs will include. So you'd have to look at, in some regards, the two figures together as the overall cost of opening up that site would be, including the infrastructure development allowance of 25,000 plus the £11,000 for the assumption for other 106 costs, because the generic sites cost rather strategic sites. So overall, that sums to around about £35,000 a unit for this size of site. That's quite a considerable sum to pay in terms of other comparables.
Yeah, I think this is one of the problems with when discussing site costs and Section 106 costs and abnormals, is there's a bit of lack of clarity as to what each of those includes. I'm kind of reluctant to accept that Section 106 costs include an element of site opening up costs. I think they're two distinctly different figures, and you do treat them differently in your report, don't you? So I'm not quite sure I've understood you correctly in suggesting that the 25,000 per unit allowance for 106 costs could include an element of site opening up costs. Or is the point you're just making that the two figures together is quite substantial and should cover both?
So yeah, I mean, obviously it's quite substantial and should cover both. I'm just, while we're talking, on hold, leaving you on delay. I'm just want to see what the IDP figures would include, and effectively this is based largely as well on the county council's development obligation for these sites. So strategic infrastructure and allowances that allowed for, say, in Harmon. Harmon gives a rough idea. It's not an exact science, as I said, but somewhere between.
Sorry, you've just gone on mute again.
Oh, sorry, I'm not sure.
Somewhere between, you said.
So yeah, so even if you look at Harmon Guide, refers to large sites will have other big costs on them, and that may include schools. It may include spine roads to open up the whole site, and it will include also the access into the site from maybe other big highways. So, and they said there's an allowance of around about somewhere between 17 to 20 odd thousand pounds.
23,000, yeah.
Yeah. So, but if you look at the combined figure of the 106 now, that will include strategic site costs as well. So things like infrastructure for schools, for community facilities, things like that. That's already in that £25,000 figure. On top of that, we quite rightly asked the developer, excluding what the infrastructure development plan would be asking for, what would be the other costs that you see that you need to envisage to bring your site forward? And that's where we got a figure of £10,900 back from that site promoter. So that was the available evidence at the time, which is why we tested it.
Okay. Okay. Yeah, Ms. Parrott, to add something to that.
Yeah, if I could refer you to page 146 of the. Oh, I've got the wrong one. Oh, it's still the same in the. It's the same in the addendum as in the original IDP, but page 146 in the original IDP. I'll let you get there quickly.
Is that?
So these are the infrastructure costs associated with site HO13, and as part of that, there's £3.723 million associated with highway infrastructure, which factors into that per site cost.
Just let me get there. I'm sorry, I'm not as quick as you think on this one for some reason.
That's all right. It's got lots of tables and stuff in it, so it's a bit slow.
Yeah. Yeah. Page 149, just bear with me.
It's all right.
Okay, that's fine. Now, yeah.
So within that, we've made an allowance of £3.723 million for route improvements. When we were initially looking at that, that was a link road through the site. That didn't prove popular with residents, and various other options were looked at in terms of accessing that site, but we kept the 3.7 million there to allow for flexibility. So certainly a considerable amount of was allowed within the section 106 element for being able to actually access site HO13, because there was an issue about where it could be accessed from as part of the actual local plan examination. So a big allowance was made for the transport element of that.
Ah, I found it. Okay. Okay. Is there anything further you want to say, Mr. Tatton, Mr. Ryder?
It was just in response to Ms. Parrott's comments. Was she suggesting that that package is no longer required, or that an alternative package will be required, but the detail isn't known?
I'm implying that an allowance of 3.7 million was allowed for access arrangements into the site. Whilst that was initially assumed it'd be a link road, it could be some other arrangement of accesses, but certainly 3.7 million is quite a substantial amount to allow for access arrangements.
Although, well, I'm glad you clarified that, Ms. Parrott, but I don't read that as being access arrangements. I read it as being route improvements to the A129 off-site rather than access into the site. So it says Thundersley A129 route between Rayleigh Weir Junction and the Victoria House Corner Junction. So yeah, I'm not quite sure. I'm not familiar with those junctions, but I'm not quite sure whether that includes access into the site or off-site road improvements, which I would expect to be part of a 106 package, but not necessarily site infrastructure opening up costs.
So it involved access into the site from both Stadium Way and from Dawes Heath Road, and then because those accesses were not going to be linked by highway, although there would be a bus route and walking route and so forth through, they'd also require some improvements around the Woodman's Arms junction and the Stadium Way junction as well, but both of those form part of the access into the site because of the shape of the site and so forth.
You're saying that figure there, route improvements on the A129, includes all of that, although it's not actually stated in there.
Yes.
Okay. Does that help, Mr. Tatton?
It provides some further clarification, although we're talking about section 106, and I'm not sure whether some of those costs would fall under section 278.
Yeah.
But we can classify them as a planning obligation, yeah.
Okay. Thank you. It is just gone 1 o'clock, so I am going to just leave it there, and we'll come back at 2 o'clock. Again, I think we're making reasonable progress. I don't have much more to ask on section 106 costs because I've got some very useful responses on those from a range of parties. I do want to have a good discussion about benchmark land values and sensitivity testing, and then we'll move on to just talking generally about the residential rates and the buffers, and also brownfield, particularly in respect to brownfield sites. So I'm fairly confident we should get all that done by sort of mid-afternoon, with a bit of help. And then just to let the council know, I haven't got a vast amount to ask on retail development, but there are a couple of questions I want to pick up on. So we'll need a little bit of time on that. I've nothing further to ask on general issues or discretionary costs. So we should get ourselves finished by the end of the day anyway. So just to give you a heads up on where we're at. Okay, good. So it's just gone 1 o'clock. We'll adjourn now, resume at 2 o'clock. If you can, as before, just turn off your cameras, but stay in the session, and I'll see you at 2 o'clock. Thank you.